Hello, everyone. This is Susan Francis, the Maryland Volunteer Lawyers Service. Welcome to the third Thursday session we're having today on criminal record expungement. And it's going to be both myself and Chris Sweeney, who is our staff attorney on our workforce development project. Two housekeeping matters, and then we're going to jump right in. Today's presentation has several handouts, which is located in the handout section on the GoToMeeting page. So if you find the handouts and do the drop down, you will find an outline, the copy of the PowerPoint for today's presentation, the shielding petition, and also some court instructions. Secondly, we will be monitoring the question box throughout the presentation today. So if you do have questions, please feel free to go ahead and type those in the questions box, and we'll try to address those throughout today's presentation. So I'm going to turn the beginning of our presentation over to Chris, who's going to walk us through the first part of the criminal record shielding process.
Hi, everybody. Thanks for joining the webinar. As Susan stated, I'm Chris Sweeney, and I'm one of the staff attorneys here at Maryland Volunteer Lawyers Service. And we are going to talk about shielding of criminal records under Maryland law. So as we all know, court records are almost 100% of the time a matter of public record. Anyone can go to the courthouse, to the records room, look at a case, look at a case file. They can be viewed on Maryland Case Search. What shielding does in the context of criminal cases is it removes that case from public view. So the case would still exist in the court system. The file would still be housed in the records department, but that case would not appear on Maryland Case Search. And if someone were to go request to look at the file, they would not be allowed to do so, except under certain circumstances, which we will explain. If you're familiar with MVLS, you know that we talk often about criminal record expungement, which is a big part of the work that we do here. Shielding is similar to expungement in that it does hide criminal records from a person's record, but there are some differences which we will go over, and there are certain factors to consider when helping out a client and deciding whether or not to shield, whether or not to expunge, or whether or not either one of those is even possible. So the statute for shielding is in Maryland Criminal Procedure Code, and that would be, as you can see, 10-301 through 10-306. That talks about the actual procedure of how things get shielded and what's eligible for shielding, and that's what we'll be going through today. So similar to expungement, if a record is shielded, then that means the person does not have to disclose that that case occurred to an employer, school, or really anyone else. And if an employer tries to inquire about a criminal case on someone's record, that person cannot get in trouble at their job for having not disclosed the shielded record. That person can't be denied an opportunity to apply to a job or be accepted to a job because of their failure to disclose that record. Another reason why you might want to shield is a circumstance where the case that you're working with cannot be expunged for whatever reason, or maybe it can't be expunged right now because of a long waiting period, but it might be eligible for shielding. So we'll get into that analysis in a minute. And another good reason to think about shielding is that when you're doing a full criminal record analysis for a client and helping them with expungement, shielding can factor into the analysis when you look at types of cases that would prevent expungement of an otherwise eligible case. So for example, in expungement world, you have a probation before judgment. That case is potentially eligible for expungement, but if you have a conviction for another case within 3 years, that would block the PBJ from being expunged. But if that subsequent conviction is eligible for shielding and you shield that case, that no longer factors into that expungement analysis, and it does not block the PBJ anymore. In terms of the actual procedure of shielding versus expungement, shielding, like I said, the record really more or less still exists as it did prior to shielding. It's just that it cannot be seen by anyone without special permission from the court. Expungement is technically supposed to be the complete removal or destruction of a case. In certain instances, they may actually literally destroy the case. But if they don't literally destroy a case, when they expunge a case, it is gone from the case search. It is gone from the court system completely. It really doesn't exist anymore. Shielding is really just hiding the case. In all cases of shielding, there's a 3-year waiting period for eligibility. With expungement, there's kind of a range of analysis that you would have to do. 10 years, sometimes 3 years, 4 years, sometimes 15 years. So it's about thinking about shielding when you're doing the big picture analysis. How does that fall in to the whole framework of trying to get criminal records off of your client's record? And then there's a strange thing with shielding law, is that you're only allowed to file a shielding petition one time in your lifetime. For whatever reason, this is written into the law, unlike expungement, where you could file one petition for one case and it gets granted, and then you could say, oh, well, this one's also eligible for expungement, let's file this one. For shielding, you can choose one court level in one county. So if you have cases in Baltimore City and Baltimore County, you can only choose one county. And then within that county, you can actually only choose one court level. So if there were eligible shieldable convictions in district court and circuit court of Baltimore City, for example, you actually can only file to shield in one of those courts, which is a little anomaly about shielding. So the statute lays out specific charges for which a person would be convicted and lists those as the potentially shieldable convictions. So you'll see things that are generally considered nonviolent crimes, things like drug possession, things like destruction of property, disturbing the peace, trespassing, and there are also some driver's license type of violations that could potentially be shielded as well, along with a certain charge for prostitution. The license thing is an interesting thing when you're comparing shielding and expungement, because right now, for the most part, convictions for these driving violations actually cannot be expunged. So shielding is a good option to think about when looking at expungement versus shielding. So this is going to be a little discussion of why you would choose to shield and not expunge, or cases where shielding would be your only option and expungement isn't available. This is just the same list of crimes that you were just looking at. This is the full list on one page. And then I'm going to pull up the analysis for all of those specific statutes. So as you'll see, when it comes to shielding, like I said, it's always a 3-year wait. from the conviction. And then when you look at expungement, a lot of these have different rules applied to them. So most of them are a 10-year wait for expungement, and that would be 10 years from the completion of any sentence or probation. But some of them actually are just not eligible for expungement right now if it's a conviction. That could, of course, change in the future, but right now this is how the law stands in Maryland. So you might have a client with a malicious destruction of property conviction, and you're helping them with an expungement analysis, and that's something that you say, oh, well, that unfortunately is not eligible for expungement because you were convicted of that charge. And that could even be something that's blocking another case that would otherwise be eligible for expungement. So that's an instance where you could look at the shielding statute and say, okay, well, we can actually shield this malicious destruction of property case as long as it's been more than 3 years, and of course, as long as we don't run into any of the other issues that would prevent shielding, which we will get into in just a minute here. So once a case gets shielded, there are specific guidelines in the statute about how someone could actually look at that case again. So as I've been saying, shielding is not the complete destruction of a case from the court's record, it's just hiding it. And of course, there's going to be exceptions for when someone could look at that file. So this is a list of people who could potentially look at a case that has been shielded. Obviously, the police for legitimate criminal justice purposes. Certain types of employers have the ability to petition the court to look at that. And then when you're getting into territory like people who are working with children, school system, certain employers who are required by law to look into criminal background. And then, of course, the person who actually filed the petition for shielding or that person's attorney could ask to look at the case as well. Now, in most of these circumstances, the person is going to have to file some paperwork with the court to get permission to look at shielded records that would otherwise not be a matter of public record any longer. And with that, I'm going to turn it back over to Susan to continue talking about how to shield.
Thank you, Chris. Let's pause and check and see if we have any questions before we.
Yeah.
Okay, good. No questions as of yet. But we, like I said, we will be monitoring this, so please feel free to. Oh wait, there's a question here.
I think you might be able to like drag, or maybe just click. Yeah.
Okay. So here's a question. When a foreigner applies for green card, the immigration office requires people disclose all criminal records. If a criminal record is expunged, will the security check still show the previous criminal records? Do you want me to answer this, or do you? Well, why don't I start? And then you can
start,
chime in.
and I'll fill in if I have.
So this is a great question, and so MVLS with 99% of the services that we offer, someone's immigration status doesn't make any difference to any of the legal services that we provide. One of the exceptions is around expungement, generally, so whether it's expungement, shielding, or vacatur, because the question here raises the concern that we have, which is that the security check will show up those potentially previous criminal records, and the problem it creates is on the federal Okay, so we thank you everyone for chiming in that we lost the audio. For some reason, our phone is disconnected, but we should be back up and running. We're not sure what the technical problem is, but hopefully we're back on track. If it does disconnect again, please let us know. We've not had this happen before. So what I was saying about shielding, this slide here, is because you can only shield once during your lifetime, it's really critical to get the full picture of what is on that client's record, because you could potentially be putting yourself at risk at some sort of complaint. And that our policy within our organization when we're filing shieldings is that we do require a criminal record report from CJIS, the Criminal Justice Information System, or one of these other sources listed on the slide. So you want to do that case search analysis, you want to get their criminal record report, and then also talk to the client to make sure you understand everything that's on their record before you file anything with the courts. Because of that, you can only file one time.
Try just clicking.
Okay, so this is the process. So as Chris had mentioned, you can only file in one court and in one county. So these are 3 questions I have for you. So this is our client. They have the following on their record. They have a disorderly conduct in Baltimore City District Court and a disturbing the peace in Baltimore City Circuit Court. So we want to know, is this shieldable? Secondly, they have their disorderly conduct in Baltimore City District Court and disturbing the peace in Baltimore County District Court. And then thirdly, the client's disorderly conduct and disturbing the peace are both in Baltimore City District Court, but they're in 2 different cases. And so with each one of these, you have to ask yourself, is this shieldable? Okay, so here's what we have. So in the first case, they would have to choose one, because you can see that one is in district court and one is in circuit court. So even though it is both in Baltimore City, that's not good enough. You got to get all the way down to the jurisdiction and then the district or the circuit court. And the second case, you've got 2 cases in district court. One's in Baltimore City, one's in Baltimore County. Again, that's no good either. They would have to choose because they're in 2 jurisdictions. And then the third case is they have 2 different cases, but they're both in Baltimore City District Court. And this one, you can file for both of these cases. So you could have 20 shieldable cases, Baltimore City District Court, over any amount of time, and you could put those all in one petition. So as long as it's within the jurisdiction and within the same court, you can file multiple cases on the one petition that you would file. And I'm going to show you that petition in a moment here. And so this is just going over what we just talked about. So multiple counties, they've got to choose. If it's a district or circuit case, they have to choose. If they have the multiple convictions in one court, in one county, then you can file it all in one. And so then I just, sort of offer as a caveat here, if you have a client, and this is not uncommon, where they have multiple charges and multiple counties, you really want to talk to them about whether shielding is going to accomplish what they're trying to accomplish. And that's because it can only be done once in their lifetime. And it may not be worth using that one opportunity, since you're often only going to be able to perhaps remove one item from their record. We're still okay? Okay. Of course.
There is a question.
Yeah. So I'll just finish this slide and then we'll grab the question. So that's the first thing you want to, so for example, I have had clients that have a lot on their record, and the one thing I could expunge for them was a suspended license. And it wasn't really going to help them because of the other things that weren't eligible for expungement or shielding. And so in that case, we probably wouldn't pursue the shielding because you're really utilizing this one relief in their lifetime without being able to get the effect that they want. The second consideration you want to consider is have they stopped engaging in criminal activity? Because again, this is a one and done in your lifetime. And so, if they're kind of in the part of their life where they're still kind of getting caught up in a variety of activities, using that shielding option right then may not be the right option for them. Okay, so we did we're backtracking a little bit because of the technical issues. We did answer the criminal records for immigration. So let me just pause here really quickly to say, in case anyone missed that there is a concern when a federal immigration process has access to criminal or has access to records that would then potentially be different from state records, and that can definitely be a barrier for that client seeking some sort of citizenship status. So we generally at MVLS, and I think across the board as legal service providers, don't do expungement or shielding for someone that is pursuing citizenship status because of the danger of that incongruity between the two records. If someone does pursue that, they want to make sure they have multiple certified copies from the court so that when that discrepancy shows up in the immigration process, that they can demonstrate why there is that discrepancy. But it's not just enough to have a copy of the order. You need that certified, several copies of the certified copies from the order. Okay, so in terms of the petition, you will see that it looks very similar to the expungement petition. This is the standard form to use, which I'm going to show you in just a minute, and it's also in the handouts. The filing fee is the same as an expungement petition, which is $30, and the filing fee waivers that we use for all of our cases, including all of our expungement cases, applies, so you can use the filing fee waiver. And then, as Chris mentioned, the waiting period is the 3 years, and it's the 3 years at the end of a jail term, probation, parole, or mandatory supervision. It's not 3 years from the disposition date, which is the date in which they were found guilty. So this is what it looks like. And again, you can put multiple cases on this form. So you can see here, so say you had a disorderly conduct, this is, say it's Baltimore City District Court, you could have a disorderly conduct case from 2010, and then a disturbing the peace case from 2005, and then a, possessing a controlled dangerous substance from 2014. You just list all of the cases that are eligible for shielding on this one form, and it goes in as one request. And then that's the remainder of the form. And you can see some of the things the petitioner needs to attest to at the bottom, which is that, and we're going to talk about this in a minute about the unit rule, that there's nothing within this particular case that isn't shieldable. At least 3 years have passed. There are no pending criminal charges, and that they have not previously been granted shielding. And then there's the signatures at the bottom. So there are, in addition to the items we talked about already, there are some additional barriers, and these again are very similar to the expungement process. So the unit rule applies just in the same way that it does for expungement. And so if you have an item that's not shieldable, and then it's also, then none of it can be shielded. You also might want to think about, particularly when you're looking at that waiting period, there's sometimes a strategy in terms of there's other things on the record that could block that shielding that are expungible. So you can file the expungement petitions first, remove those from the record, and then come back and do that shielding petition. And then again, no pending criminal matters. And then this is one other barrier to shielding. There is this exception that if someone has a guilty conviction and it's related to any of these domestically related crimes, then they can't be shielded. So when you're doing the analysis, you need to also make sure that none of these apply. And then after you file, much like expungement, the court forwards the petition to the state's attorneys. They have 30 days to object. And now this is a little bit different. The court sends a written notice to the victims in the case, and they have an opportunity to provide relevant information. And then if the state's attorney objects, a hearing will be scheduled. If the victim objects, but the state's attorney doesn't, then a hearing does not need to be scheduled. But similar to expungement, if there is no objection, then the shielding petition should proceed just in the same way that expungement does, in that a hearing does not need to be scheduled, and the judge should then go ahead and shield it just in the same way in which they do their expungement orders. And so you'll want to set your timeline when you file an expungement petition. You'll want to set the same sort of timeline, about 6 months, depending on the court. If it's a smaller jurisdiction, sometimes it's a little bit shorter. Make sure that you get your date stamped copy if it's a non-MDEC county. And then just again, like you do with expungement, once you get the order, you want to make sure it's been removed from case search. So that is the entire shielding process, but we also wanted to pause and do just a quick update for those that weren't able to join the expungement training we did last month to highlight a few changes that went into effect October 1st, and then just see if folks have any additional shielding questions. Chris, you're doing this, right?
Sure.
Okay.
Okay, so just as a quick summary of some of the updates that went into effect for the expungement statute, there was an update to the actual court form in October, and then actually it's since been updated again in December, which with slight changes, but make sure that you're using the most recent form, which can be found on the court's website and which is also part of our MD expungement web tool. There was some clarification to the law to state that civil citations fall under the same analysis as crimes do when you're looking at what can or cannot be expunged. And then pretty new to expungement in Maryland was the addition of the potential to expunge felony convictions. And those are first, second, and third degree burglary. But it's important to note that fourth degree burglary is not included in that list, which was probably just an oversight. And then felony theft, so theft of items that would total above a certain monetary value, which has changed over time, what that threshold is. Our rule of thumb is that if the charge says theft more than, and then a amount of money, that generally means that it was being charged as a felony at the time. And then drug possession with intent to distribute was also added to what could potentially be expunged. And it's important to note that that is possession with intent to distribute. It is not a charge for CDS distribution. So the actual act of distributing is a different crime than possession with intent to distribute. So it's important to double check what the actual charge was. And going back to really old cases, the language is actually somewhat ambiguous. So it's important to check if you have an old case, especially important. And all of those felonies are 15 years from the completion of any sentence or probation. And of course, there cannot be any ineligible convictions within that time period in order to expunge those.
So this is our contact information. You should feel free to Okay, thank you everyone for alerting us again. Our apologies about the technical problems we're having today. Chris and I, we came in here early, we tested everything out, and we have no idea why our phone keeps disconnecting. So I appreciate you letting us know that we're having audio problems. I know we missed a few slides in terms of explaining anything, but unfortunately I don't know which slides we missed in the middle of the presentation. So if you have any questions or if there's a slide you want us to review, please type that into the question box, and we're happy to try to answer that for you. We'll also be sending out, after today's webinar, the recording and the materials. And as I mentioned, and I think this was part of the part in which we were disconnected, this is both Chris and I's contact information. We're happy to answer questions you have about expungement, about shielding. I mean, I would say in our time here, Chris and I literally have filed probably thousands of petitions at this point, and the vast majority of them have been expungement related. The shielding can be really helpful. I had a client who the one thing he really needed removed was that malicious destruction of property. It was an employment barrier for him. And as Chris has reviewed, that's not something that's expungible, so I was able to shield it for him. But most of these cases are going, you can see there's a lot of overlap, and oftentimes you're going to want to pursue that expungement option. But there are times where either, you know, they're at the 3 years and they really need to get this removed, so we might pursue shielding versus expungement, or in these few areas where shielding is not an option. Okay, after criminal record is expunged, can the person still get, no, that's a great question. So the question is, after criminal records is expunged, can the person still get a certified copy of the court order? No, it has to be at that time when that order is issued, and that's why it's so critically important, because once it's expunged, it's gone. And so if you're helping someone expunge or shield a state record, and they also potentially now or in the future are going to be pursuing an adjustment of their immigration status, you want to make sure, you need to make sure you get multiple copies, that they're certified, and that you hold on to them, because you will not be able to get them in the future. Like I said, Chris and I are happy to answer any questions about this process. Shielding is of limited utility, but it can be really powerful when it does work for one of our clients. I just wanted to also highlight, okay, can you just specify the charges that cannot be shielded? If charges related to domestic incident, it cannot be shielded, correct? Yes, so why don't you go back one more? So these are the barriers to shielding. So again, the unit rule, if everything can't be shielded within that case, so say you have 2 convictions in that case, and one would fall under the shielding analysis and one would not, then that case cannot be shielded. Secondly, no pending, so no active criminal case. And third is the waiting period. So you have to wait 3 years, and they cannot get another conviction in that 3 years that can't be expunged or shielded. So what you would need to do is, if it's something that could be expunged but not shielded, is that you would first file for that expungement, and then once the expungement is taken care of, then you could file for the shielding. But if it can't be shielded or expunged, that's a complete bar to anything within that 3-year period. And then the second piece of this is absolutely to the question about domestic violence. So anything that's considered a domestically related crime, and that's the relevant statute, cannot be shielded. So every one of these things applies in terms of what is a bar for shielding. You want to go on? So just a reminder as well, I'll go on to the next slide. We do offer a lot of resources on our website. The attorney resources section, there is an expungement, specifically expungement area where we have a lot of information, and we will be posting information, the same handouts that are available to you will be going up on our website in that section. And then also to highlight, if you want to go to the next slide, the pro bono portal. So there is no case acceptance requirement for today's training, but you're always welcome and invited to visit our portal and see what cases we have up there waiting for placement. And then these are some of our additional upcoming trainings. We have a very full schedule of trainings in the next 4 or 5 months. So these are a few, but we have trainings scheduled out into March, April, and May as well. I just didn't want to make the slide so small you couldn't read it. But all of our trainings are free. Some come with case acceptance requirements and some do not. And I think that's all we have here. We can stay on the line for a minute if anyone has any final questions. And again, we'll send this information out. It will have both Chris and I's information, and I'm happy if you come across one that you think might be ripe for shielding, we're happy to take a look at that and kind of talk through what might be the best process. And so we'll stay here for a minute again if anyone has questions, but thank you so much for joining us. Again, our apologies and your patience for our technical issues today, and have a good afternoon. Thank you. Go up to the right here.
Yeah. Yeah.
Go over this.